You are listening to continuing coverage of the trial of Chad Daybell from True Crime Today and the Hidden Killers podcast. Let's go back to the courtroom.
Quick question.
Go ahead. I saw you.
We're talking about two different things here. Because that's saying about this case, which I agree with, right?
I'm talking about.
But there was also
Hold
a
on.
personal side.
Hey, wait. We cannot talk at the same time as each other, so we need to have a question and answer for the court reporter.
He's 438.
Mr. Pryor, if you just pose a new question, and then let's make sure to not have that.
And I apologize, Jerry. I wasn't talking specifically about the case about speculation. I was talking about major decisions in your life, how you go about making decisions about those. So go ahead.
Well, sometimes I don't have all the facts and like major decisions. It might be a financial decision, buying stocks. I collect all the facts that I had at the time, but there is an element of speculation when it becomes personal. I have to make a decision.
Okay.
So that I'm just saying there was some questions about personal, and then it went down this case, and I kind of like separated the two just based on the questions.
Okay. And lastly, and then maybe lastly, I don't judge. I listen to country music, and I enjoy it. Some of you look horrified. And there's a song that I like occasionally play. It's a song that says, "Everything that glitters is not gold." And it talks about relationships. And I see some heads shaking, 1, 12, 11, 1, 1, 1, 2 shaking. Tell me what came to your mind when you heard me say that? You know the song?
I think so. And I mean, I agree. I think there's a lot of things that are distracting or that might look really nice or things that you think are good things, but then you realize they're not. And the things that probably are worth more gold are things that aren't tangible. So yeah, I agree with that, there's not always a base value of everything. It's not obvious.
And would you agree with me, and all of you agree with me, that sometimes you look at something and it's shiny and it looks great. It looks like a wonderful opportunity. And then when you delve in deeper, you realize that maybe this glittering gold isn't what it's been represented to me. And that's juror number 537. Talk to me a little bit. I see you nodding your head.
Yeah. For instance, if a job opportunity is presented to you and they really hype it up and say, this is going to be so much better than what the place that you're at already. It's going to be the same thing that you're doing, but we're going to give you more money. The culture is going to be better. It's going to be better emotionally and physically for you. And you go, oh, yeah, because you're maybe not super content where you're at, but you like what you're doing. And then you go to this other place and you're doing the same thing and you still love what you're doing, but it's not what they said it was going to be.
And the problem is that if we're talking about a job, you quit your other job. You move on with your life and you put some investment into something. And you believe all these things, whoever it is telling you that this is gold and you're going to love this. And then when it's too late, you find out it's not gold, it's bogus basin and it's fool's gold. You all know what I'm talking about. That's a real situation. Would you agree? Would everybody agree with that? People fall into that trap very easily. And it's very easy to get people to fall into that and dangle them the gold in front of them. And all of us are susceptible to that. And when you fall into that trap, it's painstaking, isn't it? Do you agree with that? Especially if it's a job. Folks, I want to thank you. You made this very easy. And I hope I haven't inconvenienced you or embarrassed any of you. And please, I want to thank you for your time. It's important that we have a chance to meet each other and talk about these things. And I appreciate the time that you've given me today. Thank you, folks.
All right, thank you, Mr. Pryor. What I intend to do next, let's have the jurors excused, we'll take a mid-afternoon brief recess and start with our individual board dire. However, just before we have the jurors excused, there's two I'll just have stay together with some questions on the juror affirmation. So we've got juror 240 and 265. And if we could have the rest of the juries retire for a minute, and I'll pass to counsel these for their review, and then we'll have a few questions on that, and we'll continue in individual.
Your Honor, I think 265 was already excused.
Oh, apologies, I should have been tracking them. So we'll only need to talk to 240 then.
All right, great. Yes.
All right, juror 240, we excuse the other jurors. I just had a question and wanted some clarification in your juror affirmation form.
Yes.
And you made a notation and said, quote, have watched the jury deliberations. So,
I think it meant selection, but yes.
okay, so let me just clarify that issue. You filled out your questionnaire, and then after that is when you did watch some of these proceedings that were being live streamed or something?
Yes, I was curious about what questions would be asked of the jurors, and I knew that the jury selection was being live streamed, so I pulled it up and watched maybe half an hour of it.
All right. And I appreciate your honesty on that. Did you understand that you were advised not to do that?
I guess I didn't think about it at the time, but I also didn't think that official court business would be an issue. Yeah, I guess I didn't think about it at the time.
Okay. I guess the concern I would raise is if this is a continuing instruction and if we make it more clear, is this something you think you'd be able to refrain from doing and follow the instructions, including not watching any further proceedings either now or when trials taking place?
Yes, that would not happen again.
Okay. I want to have a little additional voir dire from the state and the defense just on that issue, and then we'll determine where we are. And in fact, just in the interest of efficiency here, if we want to just do the individual voir dire first with this juror, let's just go ahead and do that. But the first, I do want to bring up the subject of that with the affirmation. And again, I very much appreciate your honesty in advising the court of that. And I think that does say a lot that you did advise us. And I can understand that may not have been entirely clear and may not have been clear to you that we were actually going to be broadcasting these proceedings. So if the parties are ready to do that, do you state any questions regarding that comment in the affirmation?
Not with regard to that comment, Your Honor. Thank you.
Mr. Pryor.
Judge, I do have a comment in regards to that, but it touches on what he said in his questionnaire. One of the comments he made in his questionnaire, if the court would give me some latitude. If you don't, and you would rather wait, I can wait, Judge.
Yeah, I will. There's some potential bias in here from pretrial knowledge also. So if you want, we could just start with looking at that issue as well. And
Your Honor, if we may have just a moment to confer with counsel.
why don't you do that, and then we'll just take up sort of the full individual questioning of this juror on individual voir dire.
Thank you.
Yeah. Okay, we're back on the record now. We had a sidebar discussing briefly with counsel the issue as well as topics raised in the questionnaire for juror 240. The court understands that the parties would essentially stipulate and agree that 240 may be dismissed based on responses for bias at this stage. Does the state move to strike this juror based on that?
We do, Your Honor.
All right, any
That's as
objection?
well, Judge.
All right, well, juror 240 again, thank you so much for your honesty in filling that out. For reasons also stated within the questionnaire about some knowledge of the case as well. We've determined that it would be inappropriate for you to serve in this case, just mainly based on that prior knowledge of the case. And so for that reason, you will be excused. And we appreciate you coming in, filling out your questionnaire and returning today. You may submit your questionnaire to the bailiff there, and you are excused from service.
Thank you.
You're welcome. All right, let's take a recess here, and then we'll come back on the record for further individual voir dire of this remaining jury panel.
All right, please.
Thank you. Please be seated. All right, at this time, we're going to take up additional individual voir dire with jurors. We are back on the record on KCR 22-21-1623. My intention and order will be the front row farthest away to my left, and then the back row in that same order. So the first juror we'll have brought back will be juror number 1112. Is the state ready to proceed with voir dire?
Yes, Your Honor.
Is the defense ready?
Yes, Your Honor.
Okay, thanks everyone, and we'll instruct the bailiffs to please bring that juror in. Hi, welcome back. We're going to do some individual voir dire questioning with you at this time, juror number 1112. As we get started, the first issue I just wanted to raise was the timing of your appearance, I guess I'll say, and non-appearance. I think it was yesterday. And I did want to know if there was an explanation about how you missed the timing for the first time you were supposed to be here.
Just an embarrassing one. I just completely misunderstood the directions, and I knew I had to check in, and I had my phone, and I was like, oh, I'll just call in, and didn't recognize that it was just different instructions. And so once I found out that I had missed the correct way to log in, and then I missed my number, I called and I apologized and just said, if there's still an opportunity, because I filled out the questionnaire, I kind of did all that prep. If there's still an opportunity, I could show up for this, since I already did that prep work. So just me not looking at the instructions fully. So.
Okay, well, and I appreciate the explanation.
Yeah.
And not trying to just put you on the spot on the issue, but we obviously will need to have a lot of instructions followed, timing to be here. And you think generally you're a dependable enough person that we could count on if in fact you were here determining this trial?
Yes.
Okay, well, thank you so much for the responses and the explanation on that. Moving on then, for the remaining issues here, the courts looked at the questionnaire in this case and did see that you've somewhat followed this case in terms of knowing about it, or maybe watched some media about it, you know, some details of it. And I would like to start there with questions of possible bias. On your questionnaire, you said you did have some kind of personal opinion or belief, and one of the ways you stated it was, well, a couple different ways. Circumstances seemed too obvious that he was involved, and it is obvious he was involved in some way. So, and again, your feelings on this, we want to know really accurately where you stand on that to see if you are or could be impartial in the case based on what you already know. So when you answer that way, do you have some presumption already in your mind potentially about him being guilty?
No.
Okay, and to explain, when you say involved in some way, what first of all, what do you believe he is involved with?
Just because of seeing what's on either the news or in any of the coverage, obviously he was there on the video, and he was with Lord Vallow. So just seeing that on the media, so I knew that they knew each other. I knew that they, I think, were married. I can't remember if they were officially married, but anyway, so I knew that they knew each other. So from all of the things that were shown on the media, just by knowing that they have a relationship, there's that circumstance that there may be some involvement with each other for sure. I don't know about the involvement in all of the different pieces of the case, if that makes sense.
Okay. All right, at this point, I want to have counsel inquire further on the issue of potential bias here. So we'll begin with the state and any questioning and then move on to the defense.
Thank you, Your Honor. Juror 1112, and just again, no right or wrong answers. Just feel free to tell us the way you see things. Looking at your questionnaire, it looks like you've followed East Idaho News, actual court summaries of Lori Vallow. Does that mean, did you look at some of her trial or listen to some of her trial?
The East Idaho News, my husband's from that area. And so that's probably what piqued our interest. And then somebody told us they're doing summaries of what's happening in the case. And so, yeah, we would occasionally look in that and just see kind of what was going on because of the different ties to the area and things like that. We wanted to see what was going on. It's very covered.
Yeah, there was a lot of media.
Yes.
And so you've also seen the Dateline and the Netflix.
Yeah.
So you understand that this defendant has an absolute right to a presumption of innocence.
Yes.
On the bottom of page 15 of your questionnaire, you say, and I think the judge might have already pointed this out, but circumstances and evidence the news show seem to point a guilty picture, but I will look at the actual evidence. Is it possible that if you were to sit in judgment on this case as a juror, that you would have some of those things you've heard in the back of your mind?
I really don't think so. I'm not one that watches a whole bunch of news stories and things like that, but the one thing I have realized is the media says what they want to say. And by being part of this trial or any sort of a trial, there's so much more evidence I know than what they are going to say on the media. So to me, that's the way the media is across all things, politics, trials, whatever it may be that we're covering. They're going to show what they want to show, and you're only seeing this small viewpoint. So to me, it's easy because I already feel that way about what you see on either social media or even just in the news. So it's easy for me to really just look at, I know I'm going to see evidence in this trial that probably did not even make it into anything else. And so you have to take what's in front of you to really decide, because there should be a lot more than what I even think I've seen out there. So yeah, I think it would be easy.
Should the state or the defendant be concerned at all that because of how much media you have seen, that maybe you're waiting for something to be shown that doesn't get shown, that maybe there's something in those media reports that you think is important and that doesn't end up in court?
No, because I would not say I followed it enough to know what even would be left out or what would be included. It was just definitely a high level, hey, what's happening with this, not knowing or remembering necessarily what all was shown in the media or in all of the different outlets. It was just definitely on a high level, hey, this is going on in our culture right now. So no, I wouldn't be looking for anything because I don't think I would have, nothing would have stuck in my mind.
Okay. Thank you for your honesty. Thank you for your answers. Your Honor, given just the nature of what was put in this questionnaire, and with all respect to Juror 1112, the state does have some concerns that just so much has been seen. And so we would move to have Juror 1112 excused for cause.
All right, response from the defense on the motion.
Well, Judge, I really appreciate Judge 112's sincerity. I really do. But my concern, Judge, is unfortunately you watch the Netflix thing. Then you watch the Dateline thing. Then East Idaho News. You watch the summaries. And I understand your explanation about that, but those questions kind of said, did you form an opinion? And you kind of said, well, it kind of points towards guilt. I'm a little concerned, Judge, that, she's going to be able to look at this stuff, but in the back of her mind, she's going to say, well, I saw that on Netflix and all of that. So I'm deeply concerned about that, but it's not to imply anything about you. I think I really appreciate your honesty. I really do. But thank you. And Judge, I'm just going to also move to this.
All right. I've considered the responses here too as it relates to bias and equally share the concerns raised by the defense and the state that there just might be too much already known information about this case, including facts, which could lead to some improper speculation. So again, this is nothing personal at all. We appreciate your candid responses in the questionnaire as well as before the court today. And with the sincere thanks to the court, I will grant a strike on juror 1112 for perceived bias or actual bias, and we will allow you to be excused. So thank you for returning for further questioning. If you'd please drop off your questionnaire with the bailiff, then you may be excused for the day. We'll next speak to jurors 1623. Welcome back, juror 1623. We've got some further individual questioning for you at this time outside the presence of the other jurors, beginning with questions about your knowledge of the case. You do indicate in your questionnaire you followed some of the case, you do know some of the details, so this would be the time for us to be able to fully discuss that, where other jurors wouldn't be hearing what you know, but we would like to delve into that. So I don't see anything in particular that I feel I need to voir dire on, but I will allow the state and the defense to ask some questions. One issue I just wanted to ask you about, I guess, in the questionnaire where you talked about what you've seen, you did say State versus Lori Vallow, news reports, and final verdict.
I did, yes, I did watch the final verdict when it was televised.
Okay, so that was televised and you observed that as it occurred?
Yes, I did.
Okay. All right. Did you watch any other parts of that
No,
case?
I did not. No.
A sentencing hearing?
Just the one that was televised at the very end. When the full verdicts came down. That's the only time I didn't watch it any other time.
All right. Thank you for the response there. If the state has any voir dire on this issue, you proceed.
Thank you. Thank you, Your Honor. Ma'am, I do have a couple of questions. On your questionnaire on page 18, you were asked, what have you heard or what do you know about Tammy Daybell, Tylee Ryan, or J.J. Vallow? And you had responded, among other things, that what you hadn't understood was that the children's bodies were found on Mr. Daybell's property, and that Tammy Daybell's body had been exhumed. I just wanted to ask, those are substantial allegations the state is making in the case. Have you inferred anything from that information, anything at all about Mr. Daybell?
No, I have not.
So even though you've heard about those allegations, you think you can set aside
Absolutely.
influence?
Facts are facts. That we presented.
She just doesn't want us to talk over each other. So go ahead with your answer.
There's no decision of anything else. Facts are facts for me. And that's what I have to see in order to make a decision.
Okay. Just 1 second, ma'am. And then just in that same vein, on page 22, you noted that you believe that Mr. Daybell had claimed innocence in knowing where the children's bodies were, but then they were found on his property. So you made a point of noting that.
Right. I was talking about when they were there in Hawaii, and he said he didn't know where they were at, but then the news, everybody's saying that it was found on his property, and that I didn't learn anything else past that.
Does that information cause you to infer anything about Mr. Daybell? Would you be more or less likely to believe him if he chose to testify?
No, I would not.
No, I don't have any more questions on this point.
All right, Mr. Pryor.
And ma'am, again, there's no wrong answer. And when you heard all of that about what happened in Hawaii, did you have an opinion that Mr. Daybell may be guilty?
I couldn't make an opinion. Unfortunately, the news doesn't always share everything that they want that you should know. So I can't make an opinion if I don't have all the information in front of me.
And then you watched Lori Vallow's being convicted?
Yes, I did.
Did you, at that point, you obviously had an opinion of revalid, right?
Opinion is not the right word. It's what came down to what the jury found for her statement or for her closing case. My opinions, everybody has an opinion, but I have to have a fact in front of me in order to make the decision, or to the best of the ability to make my decision.
So even if you had an opinion, about Mr. Daybell, what it sounds like to me is that you're going to be able to push that aside and still just evaluate the facts. Would that be fair?
Yes, can I add to that? My profession is human resources and safety.
Okay.
So I have to have the facts to make a decision. So I'm always investigating situations down to the final decision. So that's how I make my decisions.
So there was obviously some interest you piqued some interest in this matter. Now, would that be fair?
Yes,
And if I understand, you looked at the announcement of the plea on Lori Vallow. And again, what else did you look at? Remind me again.
it was when they were in Hawaii and they stated they didn't know where the children were.
And you saw that where?
It was on the news.
You don't know which news.
It was Channel 7 or Channel 2.
And you didn't read any newspaper articles?
No,
You didn't look anything on the internet?
no, I tried to be separated from it, just so that if there ever is a decision, I don't want to be tainted to make the right decision. Where I'm at right now in jury, you never know what's going to happen.
And this is what I'm struggling with, and I'm not questioning you or anything like that, but as someone who, has a thirst for wanting to know what the facts are and wanting to make the right decision, and then I hear, well, and as a human resources, I'm trying to discover what's really going on here. So in my mind, that would sort of prompt me to look into this a little bit, because if you were so interested in Lori Vallow and interested in Hawaii, I would think you would have pushed that a little further. And then on the other hand, you're saying, well, I'm not going to make a decision because it sounds like you kind of predicted that you thought you were going to be here today.
No, the media can never, unless you're here, the media is not going to give you all the information ever. So unless I watch the hearings to see all the information that's provided, I can see the news and it's still not the deciding factor.
And I appreciate your explanation. Nothing else, Judge.
All right, thank you. Juror 1623, let me just follow up a little bit on your knowledge of a conviction in Lori Vallow's case, which was previously tried. Where you have that information, do you believe that's going to cause you to draw some sort of inference of guilt to the defendant here in this case?
I do not.
All right, and do you believe you can set that aside and deliberate only on evidence that is provided in this case?
Yes, I can.
All right, and where the jurors are instructed not to communicate with each other about anything they know about the case or until deliberations, or even going there, are you committed that you wouldn't be discussing that fact or information with any other jurors if you are on this case?
I am.
Okay. Then on that point, I think that will conclude questioning. There's been no motion for cause, and so the court also feels there's no reason for cause at this point. I don't think we had any indication of concerns as it relates to potential hardship. So I'm going to go on to another topic at this point, unless either side thinks they have any final board dire on the issue.
May I, Your Honor?
Go ahead.
Thank you. And frankly, Your Honor, I don't know that I have more questions, but I think the state would take the position that, and we appreciate the candor and the honesty, that it would appear that there was some significant information that was obtained by this prospective juror on just tracking the case. And that, coupled with what she does know about Ms. Vallow's conviction, that the state would just find it appropriate to strike her for cause at this point based upon that information.
All right, what's the response on the motion for the defense?
Judge, I think she's being really sincere, and I really believe that. But my concern is that again, just having the knowledge of the Lori Vallow case, and I think that's what cuts it off for me, and I'm sorry about that. But I think the knowledge of the Lori Vallow verdict, that causes me just to hesitate a little bit. So I guess I would just move for cause, ma'am, okay?
All right, and I'll indicate I am really wavering on this too. I do believe you as well, that you would be able to set that aside. It is, however, a pretty significant fact that if it were to come out, we don't know if that's going to come out during trial. It shouldn't, but it could. And then in the course of deliberations, there's a real concern that could persuade people against the right of the defendant to have a presumption of innocence. And so with that potential, I do think I'll permit the challenge for cause raised by the state, not objected to by the defense. So very much appreciate your time and your candor and coming back after filling out your questionnaire. Juror 1623 is excused for cause. And if you please drop your questionnaire with the bailiff on your way out. Thank you, ma'am. We'll next talk to 1624. If you're ready to answer this, counsel, I don't know that we had any specific hardship or bias concerns. They did mention something about some doctor and dentist appointments, but didn't say it'd be a hardship. Is that a topic you think we need to go into?
No, Judge, I'm going to move on from bias and hardship. I think she acknowledged that in her answer at the very top about the doctor's appointments. So I have nothing with bias and hardship to defer to the state.
Your Honor, on this juror 1624, I did have one concern with bias, but it sort of overlaps with the death penalty issue, which is just the comment that this juror wrote that under the death penalty section, that the accused gets time to prove innocence. That sounds a little bit like burden shifting to me. That was something I was going to question this juror on, but we could also do that during the death penalty portion as well, since the juror did make that statement in the death penalty portion of the questionnaire.
All right, thank you, Ms. Beatty. We'll go ahead and take that up. I'll just begin with the questions regarding the death penalty, and you can inquire on that response then. All right, welcome back, juror number 1624. We've got some additional questions for you outside of the presence of the other jurors. I believe you've been provided a copy of your questionnaire, and there's a specific section we'll be discussing within that, starting on page 12. And if you could just refer to that. The section is attitudes regarding the death penalty. Do you recall reading through those questions and answering those last week?
Yes.
Okay, and to your recollection, are those answers you provided still accurate in the way you feel about the death penalty at this time?
Yes.
All right. I want to let you know and advise you that it may be necessary for you to make a determination in regard to the imposition of the death penalty in this case or some other penalty. And remember, when you're considering that and any penalty, you need to consider it as if it would be done and absolute and carried out in the case. So in thinking about it in those terms, in other words, not hypothetically, I'll just review with you a couple of your answers. You first were asked, do you support or oppose the death penalty? You said support. Is that the way you still feel?
Yes.
Okay. If you don't mind, if you turn to page 13, and on this page, you were given a series of 7 choices to read through and elect which one best or most accurately represents the way you feel. You circled C, and that says, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still the way you generally feel about the death penalty?
Yes.
Okay. Given your personal views on the death penalty, do you believe that the death penalty should be considered or applied in every case where a murder has been committed?
Yes.
Okay, if the court were to instruct you in a case that it was not to be considered for some reason, or the state was not seeking it, would you follow the court's instructions?
Yes.
All right, so if it were not instructed to you, you don't believe then it should be applied in a case?
But if they're asking and the state laws allow it, then, you know, then it's no question then.
Okay. So let me just ask you this. Is there anything about your belief on the death penalty that you think would either impair your ability or prevent you from being a juror and applying only the instructions the court gives you?
Okay.
And it may have been confusing the way I asked that.
Yes.
Let me re-ask it. Will you follow any instruction the court gives you in accordance with the law in this case, even if that includes the death penalty or to not consider the death penalty?
Yes.
All right, that will conclude my questioning of Juror 1624. I'll allow the state if there's any for dire.
Thank you, Your Honor. Good afternoon, ma'am. So in this case, during this trial, you will be instructed that the state has to meet its burden of proof beyond a reasonable doubt. And unless and until we do that, Mr. Daybell is considered innocent until proven guilty. Is that an instruction that you can follow? And you consider him innocent with a clean slate going into this?
Yes.
So if you determine after following the court's instructions that Mr. Daybell is guilty after hearing all of the evidence and deliberating, then you might be in a position to decide based on information presented to you and based on the judge's instructions, whether or not to impose the death penalty, which is a separate decision from whether or not he's guilty. Would you be able to follow the judge's instructions and fairly consider all of the evidence before deciding if you think that the death penalty is appropriate?
Yes.
So as you sit here today, have you made up your mind that the death penalty is appropriate, or are you willing to keep an open mind and follow the judge's instructions?
No, follow the judge's instructions. I've never broken the law.
On the bottom of the questionnaire, on the bottom of page 12 in your questionnaire, there was a question: do you feel the death penalty is used too often, too seldom, or don't know? And you wrote, it depends on the laws. What did you mean by that?
Well, every state, I've lived in several states, but every state is different.
Sure.
And,
is that because you would base your decision on what the law is and what the judge instructs you?
yeah.
Okay. I just have another question for you. When on the part of the questionnaire that asks, how do you feel about the death penalty? You wrote, accused gets time to prove innocence. Now, in this case, Mr. Daybell doesn't have to prove his innocence. The state has the burden of proof. And
Oh, yeah, that's,
okay. So could you explain what you mean by that? Or
well, you know, they get so many appeals.
oh, do you mean that the accused gets time to appeal? Is that what you meant by that question?
Yes.
Okay.
Yeah.
Okay, so you understand that Mr. Daybell doesn't have a burden of proof in this case?
Right, Fifth Amendment.
Yes, okay. Thank you very much. Your Honor, I have no further questions for this juror. Thank you.
All right, thank you. From the defense.
Hello, juror number 624, where I guess we visit again for a little bit, right?
Okay.
If I understand you correctly, you're in favor of the death penalty, right?
If that's what the state is calling for.
Okay, so if the state is calling, if the prosecutor is calling for the death penalty.
I mean the state laws.
Oh, the state
There's
laws. Okay.
The state laws.
Okay, so if you're following the state law and it says, well, if you're convicted of murder and there is a conviction, you have two choices. You have the choice to impose life in prison, or you have the choice to impose the death penalty. Would you agree with that, if that's what the state law says?
I thought the jury doesn't do that.
Okay,
I
well,
thought the judge decided, you know, death penalty or life in prison.
but if the judge instructed you that you're to decide life imprisonment or the death penalty, and let's say the judge says it's up to you as the jurors, right? Are you following me?
Yeah,
Okay, and let's say the judge decides that you have to do that in Idaho. Your position is you favor the death penalty now, right?
that's
There's no wrong answer, ma'am. It's okay.
yeah.
Okay. So if you favor the death penalty, if someone's convicted of murder and you favor the death penalty, you start at the point that that person should get the death penalty unless somebody convinces you to impose a different sentence. Would that be fair?
Yes.
Okay. So if we're gonna, if you know, whoever the defendant is gets convicted of murder, you're a person who strongly believes, and again, there's no wrong answer, that the death penalty is on the table and that person will get the death penalty unless I'm convinced of something different. That is a fair statement of where you are, right?
Yes.
Okay, Judge, I have nothing else. I'm going to move for cause, Judge.
All right, response from the state?
Your Honor, if I could just ask this juror a couple more questions.
You may.
Ma'am, I'm sorry, I know this process can be a little bit confusing, and maybe in my questioning, I should have made it clearer that the jurors are the ones who decide whether or not the death penalty is imposed. But in this case, should Mr. Daybell be found guilty, it will be up to the jurors to weigh whether or not the death penalty is appropriate. And you'll be instructed that that decision can only be made after considering all of the evidence. And you'll be instructed that you can't actually decide that in advance, but you'll have to consider the instructions from the court. Are you able to set aside any personal feelings or maybe leanings that you have and follow the court's instructions and enter into that discussion with an open mind?
Yes.
Okay. And on your questionnaire, and this may have already been asked, so if it was, please forgive me for asking you again, but I believe on your questionnaire, you indicated that you generally support the death penalty, but that you would be willing to base your decision whether to impose it on the law and instructions from the judge. Is that still correct as you sit here today?
Yes.
Thank you very much, ma'am. Your Honor, the state would object to striking this juror. I don't believe that cause has been shown. I think
I'd like to revisit it as well.
I'll allow one more line of order on the issue before I make a determination, Mr. Breyer.
Thank you, Judge. So, ma'am, when you say you favor the death penalty, that's your preference, correct?
Yes.
Your idea is that that's where you would go if someone's convicted of murder. You would say, listen, I'm in favor of the death penalty.
Yes.
But isn't it still your position that in order to avoid you imposing your favor, someone's going to have to convince you to change your mind about that, right?
I lived in Florida when Ted Bundy was around.
Right. Okay. So your belief is that we impose the death penalty unless you convince me otherwise. That be fair?
Yes.
Okay, thank you. Nothing else, Judge.
All right. So juror 1624, I guess to try to summarize your thoughts here, if the state is seeking the death penalty and there was a guilty verdict, would you automatically vote for that, or would you follow the court's instruction and consider all the facts as to whether or not it should apply?
The facts would weigh heavily.
All right, so to clarify then, you would be willing to follow the instruction the court gives you, even though you may favor that as a punishment, and you would follow the law and the instructions the court gives you?
Yes.
All right, the court's going to overrule the challenge as it relates to juror number 1624, and that will conclude the voir dire individually of the juror. So thank you for returning. We'll have you go back to the jury room for further instructions as we talk to the other jurors in this case. Let's next talk to juror 1640. All right, juror number 1640 is returning. We've got some individual questioning for you here. I know we already went through questions about hardship. I did want to note in your questionnaire, you talked about a family vacation planned and paid for May 8th to the 10th. Is that still on your list of plans?
Tentatively, yes, the airlines can be rescheduled if needed.
Okay, so you are not requesting to be excused because that's something you couldn't move?
Correct.
Okay. Counsel, there was some expression of knowledge of the case in the questionnaire, so I'll commence with the voir dire. We'll have the state begin on the issue of any possible bias and then move to defense on that.
All right, thank you. So juror 1640, just again, remember there's no right or wrong answers. Just tell us what you think, how you feel. It looks like you did see some headlines from Idaho Statesman or social media.
Yeah.
What social media would you seen headlines on?
Probably Instagram would have been like the platform, and then the news outlet would have been NPR.
Okay. And would you say that you followed this case closely?
No.
Do you recall if you ever actually read any articles or just the headlines?
I have not read any articles.
Okay.
Just that.
And have you watched, do you know if you've seen, it looks like you knew something involved in Hawaii. Do you know if you watched anything on TV regarding this case?
Mm-hmm. I've not watched anything on TV. It was probably just like in conversations with like family members who may have done stuff, and we're just talking about things. But I myself have not watched anything.
Okay. Do you have your questionnaire with you?
I do.
On page 19, question 10E says, would you be able to put out of your mind what you have read or heard about this case and render an impartial verdict based solely upon the evidence presented in this courtroom? And you marked no, but then you wrote, I have not read or listened closely to any reporting on this matter. You explain that?
Sure. I probably meant to say yes.
Okay.
Yeah.
So, and just to be clear for the record,
Mm-hmm.
are you telling us today that you can absolutely commit to setting aside anything you have learned about this case and give this defendant the clean slate that he has a right to?
Yes, that is correct. I do not have any preconceived notions of anything.
Okay. I have no further questions about bias, Your Honor.
No questions, Judge.
All right. There's another issue we'll discuss next with you then, juror 1640. In your questionnaire, there was a section beginning on page 12, and that was questioning you about your attitudes regarding the death penalty. Do you recall reviewing and answering that section of the questionnaire?
I do remember, yes.
Okay, in this case now, we're not dealing in a hypothetical situation, so it may be necessary for you to actually make a determination in regard to the imposition of the death penalty or some other penalty. Remember, any penalty you're considering should be considered as if it is absolute and will be carried out in the case. So with that in mind, I'll note that you check both boxes. Do you support or oppose the death penalty? You said you support and oppose, and a note, I see both sides, but overall oppose. Is that still the way you feel about the issue today?
It is.
Okay, looking on page 13, you had another response when you were given 7 choices about what most accurately describes the way you feel about the death penalty. You chose D, which says, I'm generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Is that still the way you feel about it?
Yeah.
Okay. So as I understand it, then you do not have any opinion that it should automatically be considered in every case where a murder's been committed?
Yeah, that's probably right.
All right, and you are willing to, despite any personal views on the issue, follow any court's instructions, even if it involved you considering it despite your opposition?
Yes, I agree.
Okay, that wasn't a good question. I apologize. Let me ask you this. Do you think in any way your views may prevent or substantially impair you from serving as a juror here if you are given instructions about the death penalty?
No, I don't think that would impair my view. I think I'd be able to carry out a verdict, and my opposition maybe, or feelings of opposition would not be, would not stand in the way of that.
Okay, so back to your choice D then. You said you think you can put aside those feelings and impose it if that were called for by facts, law, and instructions?
Yeah.
All right, thank you so much for your responses. I'll allow the state if there's any more dire for this juror on the issue.
Just briefly, Your Honor, thank you. Juror 1640. On the bottom of page 12, you wrote, death penalty, in my opinion, should only be an option in extreme cases. Without getting into too much detail, what would be an extreme case?
Yeah, so something that was like really horrific, and the facts were presented in a way that showed, like, in my opinion, that individual had done something like to the extreme.
Okay.
Yeah.
And it's fair to say, I think based on what you, how you've answered your question, you don't like the idea of giving someone the death penalty,
right,
which is normal. I think a lot of people feel that way. And I don't want to retread what the judge has said, but in this case, if there is a conviction, you will get a set of instructions that you have to follow to determine if the law and facts call for the death penalty. And so even though, and we're not asking you what you're going to do, because we don't know, but will you commit to following those instructions and the law?
Yes.
I have no further question, Your Honor.
No questions, Judge.
All right, thank you, juror number 1640. That concludes your individual voir dire. I'll have you return with the bailiff for further instructions to wait while we talk to the remaining jurors.
Thank you.
We'll next talk to juror number 1761. All right, welcome back, juror 1761. We're going to have some individual questions for you, and here outside the presence of the other jurors, encourage you to let us know everything you can about the questions given to determine whether or not you're able to serve. A couple of things raised in your questionnaire I'll begin with is you did have a couple of concerns about both potential child care and also a long-term training you're involved in.
Yeah.
Do you want to, I guess, discuss whether or not either of those would be significantly impacted and distracting to you if you were required to serve for the long term of this trial?
The training can likely, I can get into another cohort of the training. I have to drop out of this one, and it would be about a year before I could get back in it, but it won't substantially impact my employment.
Okay, so stopping there, if that did happen and you were required to serve, do you think you'd feel some sort of anger or resentment that you got stuck in jury service, got behind on that, and maybe have that impact your ability to see things impartially?
I don't think it would impact my impartiality or attention.
All right, thank you. Any other concern you may have as it relates to any hardship you may suffer?
If we were to be sequestered, so I have my kids 85% of the time. So I would have to coordinate with their father. And I have absolutely no idea what his travel schedule looks like. He travels occasionally.
Okay, and without making any promises, it's hard to predict how long that would be if there were sequestration. That it could be a week, it could be more than a week. I don't know that it would be 2 weeks, but again, you can't hold me to that because it could turn out to be much longer. If that did take place, do you think that would create a real distraction for you worrying about what was going on with the care of the kids?
As long as they have an adult to supervise them, they are old enough they can manage.
Okay, well, I very much appreciate your responses there. There was some other minimal knowledge of the case. I'll let the council go into that if you wish. So I'll let the state commence with any individual voir dire, including topics of hardship or bias.
Thank you, Your Honor. And ma'am, just to follow up on that a bit, yeah, I wasn't sure if I heard what your last answer was to the court, but do you have another adult to be with your children if there's a prolonged sequestration, your husband's or your ex is out of town?
My dad is usually the backup plan. He is traveling for a couple of weeks in May. My ex has a significant other who arguably could watch them. I have friends. So, I mean, there are people who would watch the children if I were to not be available to watch the children.
So it sounds like that in this regard, you're not concerned about being in service on the jury.
No, I think they would be
okay. Excuse me. And I guess, you know, when we began this process this afternoon, the judge had asked a question if anything had changed on the questionnaire she completed, and that we have these hardships and you hadn't mentioned them. Is there a reason why you didn't bring that up, or you just didn't feel like it was an issue, or what was your reason for not bringing it up?
Because I had checked, like, if I were to need to day to day, they're fine. They're old enough. You know, they can get themselves to school and home from school and all of those things. My oldest is 18, so arguably he is of legal age. There are people who could, it would be challenging, but it's the same thing if I go away for a weekend. It's challenging to make sure the kids are covered. So it's nothing I haven't managed before.
Okay, thank you. Your Honor, did you want me to go into bias questions at this time as well?
Yes, please.
Thank you. So, ma'am, I just have a couple of other questions. I noticed in your application, you are a PhD psychologist, is that correct?
That's correct.
Can I ask what field of psychology do you typically work in?
I'm a clinical psychologist.
Okay, so you do evaluations and IQ assessments and those types of things, is that fair?
I have done those things, yes.
Okay. So my question is, with that background, if you were chosen to be a juror and let's say you heard from experts or mental health folks and you disagreed with them from your observation of the evidence and information, do you think that would likely impact your ability to be impartial and render a verdict?
I mean, the field is relatively subjective as much as we want to say that it's not. So the fun thing about the field is that you have very different perspectives on the same information. So I've learned to not trust my own opinion necessarily in the face of other people who have touched the data, who've done the things they've done.
And then maybe with the opposite situation, maybe if it's a situation where you listen to these weeks and weeks of evidence and information, and then you don't hear anything from anybody about any witnesses or parties' mental health, but you think that there should have been something or could have been a problem, would that cause you any concern?
No. No.
And in your work as a clinician, as a clinical psychologist, have you ever been involved in the criminal justice system in terms of assessing competency or things like that, criminal competency?
Not criminal competency, no.
But well, in any way, the criminal justice system, have you been? Certainly, sorry. Have you done any professional work as a PhD in any part of the criminal justice system?
I have testified in the past as a witness in the capacity of my work.
As an expert
Yes.
in a criminal case?
It was not, how would you define parental termination, parental rights termination?
So would that have been in a custody capacity as a parenting type of an issue?
It was a situation in which the state was trying to determine if children would stay in foster care or if their rights would, or if they go back to the parents.
Just one more over there, please. No, at this point, I don't have any other questions on this topic.
All right, thank you. Any questions from the audience? All right, so the next issue we're going to take up, Juror 1761, is in regards to questions you previously answered relating to your attitudes regarding the death penalty. That was starting on page 12 of your questionnaire. Do you recall going through those questions last week and answering?
Yes, yes, I do.
And I'll advise you that in this case, it may be necessary for you to make that determination in regard to the imposition of the death penalty or some other penalty. And remember, when you're considering that, you need to consider it as if it is absolute and will be carried out in the case, if that's what you determine. So as you're thinking through that, I'd just like to review a couple of your answers with you, and then I'll let counsel ask you as well if they wish. You had a couple of choices when it was, do you support or oppose the death penalty? And you checked the box saying you oppose it. Is that generally the way you feel about it?
I am not a big fan. So yes, I would say that kind of at a base level, I oppose it, but I also recognize that it's legal, so.
Okay. Going to the choices you had about what most accurately represents the way you feel, and understanding these are not your words, they're words of the questionnaire, but you selected a box or a choice D, and that reads, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Is that still the way you feel as you sit here today?
Yes.
There's more to come in the trial of Chad Daybell. Press subscribe so you don't miss any of our continuing coverage right here from True Crime Today and the Hidden Killers podcast.